In India, Hindu law is guided by ancient texts and customs. Mitakshara and Dayabhaga are two prominent schools of thought within Hindu law. They offer different interpretations on inheritance and succession. The Mitakshara school, prevalent across most of India, is our focus. It derives its name from a commentary on the Yajnavalkya Smriti, an ancient legal text. This commentary, written by Vijnaneshwara in the 12th century, is highly influential. Mitakshara law stands out for its concept of coparcenary. This system recognizes the right to property by birth. It means a son, upon birth, acquires an interest in the ancestral property. This right is not earned but gained automatically by virtue of birth into the family. This differs significantly from the Dayabhaga school prevalent in Bengal and Assam. Dayabhaga emphasizes inheritance upon the death of the father, not birthright. The Mitakshara system governs various aspects of Hindu family law. It dictates rules for inheritance, partition of joint family property, and the formation of the Hindu Undivided Family, CHUF. The concept of the HUF is central to Mitakshara law. It represents a joint family where several members hold a collective ownership interest in the family property. Ancestral property, under Mitakshara law, holds a unique position. It is property inherited by a Hindu male from his father, grandfather, or great-grandfather. This property is not earned or acquired through individual effort. It descends through generations, carrying with it the legacy of the family. A key characteristic of ancestral property is the concept of inheritance by birth. As soon as a son is born into a family governed by Mitakshara law, he acquires an interest in the ancestral property. He becomes a coparcena, a joint owner. This right is not dependent on the father's will or any other legal document. It is an inherent right bestowed by birth. Furthermore, all coparcenas have an equal share in the ancestral property. The father and sons have equal rights, and no individual can claim exclusive ownership. It's crucial to understand that self-acquired property doesn't fall under the definition of ancestral property. Property that a person acquires through his own efforts, skill, or by purchase is his own. He has absolute ownership over it and can dispose of it as he wishes. This distinction between ancestral and self-acquired property is crucial in understanding property rights under Mitakshara law. The Hindu Succession Act of 1956 marked a significant turning point in Hindu law. Before this, various personal laws governed Hindus based on region and custom. This act aimed to codify and unify these laws, bringing about much-needed reform. The act had a profound impact on the Mitakshara system, particularly regarding property rights. One of the most significant changes was the recognition of a daughter's right to inherit property from her father. Before the act, daughters had limited inheritance rights, particularly concerning ancestral property. The 1956 Act changed this by making daughters equal coparcenas in their father's property. This meant daughters, like sons, would have a right by birth in the ancestral property. However, the Act did not initially grant daughters the same rights as sons in CHUF. This discrepancy became a point of contention, leading to further legal challenges and amendments. The Act also brought about changes in the rules regarding intestate succession. Intestate succession refers to the distribution of property when a person dies without leaving a will. The Act laid down clear guidelines on how property would be distributed among heirs in such cases, ensuring fairness and reducing potential disputes. While the 1956 Act was a step towards gender equality, some ambiguities remained, especially concerning daughters' rights in CHUF. The year 2005 marked another milestone in the evolution of Mitakshara law. The Hindu Succession Act underwent a significant amendment to address the long-standing demand for equal property rights for daughters. The amendment tackled the discrepancy that existed in the rights of sons and daughters within CHUF. With this amendment, daughters were finally granted equal rights to ancestral property. This meant that daughters, irrespective of their marital status, had the same inheritance rights as sons. They became coparcenas by birth, entitled to an equal share in the HUF property. This amendment was hailed as a landmark judgment, promoting gender equality and dismantling patriarchal norms within inheritance laws. The 2005 amendment had a significant impact on the dynamics of Hufs. With daughters having equal rights, the traditional structure of Hufs, predominantly controlled by male members, began to change. Women could now demand their rightful share in the ancestral property and participate in the decision-making processes of the Huf. This amendment empowered women, giving them greater control over their economic destinies and challenging traditional gender roles within the family structure.